This is Protected Thoughts from the Intellectual Property team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit McBrayerFirm.com.
Welcome to the inaugural podcast of Protected Thoughts. My name is Mary Elise Paul, and I am here with my McBrayer colleagues, Pete Rosine, Katie Donnelly, and Bruce Paul. Today we are going to introduce you to our podcast, tell you a little bit about why we are creating this podcast, talk about our name and the painstaking process of selecting a trademark, and we are also going to cover some intellectual property news from the past few months involving cease and desist letters. As I said, I'm Mary Elise Paul. I am a member here at McBrayer. I am here with Pete Rosine. Tell us about yourself.
Hi, I'm also an attorney here at McBrayer, and I practice in the intellectual property litigation group primarily.
How about you, Katie?
I'm an associate here at McBrayer. I practice in the intellectual property group as well.
And what about you, Bruce?
I'm Bruce Paul. I'm a member at McBrayer, and I also do litigation with a fair amount of intellectual property.
I'm excited to be here with all of you, and I am also really excited that we finally have a podcast. This podcast is a long time in the making, right, guys?
Yeah.
Mm-hmm.
So, why do we have a podcast?
Mostly because you've told us we had to do it, if we're being honest.
Ha ha ha. Well, I think that we all in this room enjoy reading about IP stories in the news, and we all enjoy listening to podcasts, especially Bruce. Bruce always has a podcast on, especially at home. Bruce and I are married, for those of you who are not aware, and he often plays podcasts in his AirPods, but also has that SoundLink thing at home and broadcasts them for the entire house to listen to too. So if we're enjoying podcasts this much, we might as well have a podcast. Pete, what's your reason for wanting a podcast?
Really, anytime I get a chance to talk about movies or music, even the most remote possibility, I'm on board.
How about you, Katie?
So I'm relatively new to the IP world compared to these guys, and I'm also located in a different office location, so I don't really have anyone to just like pop in and talk to about IP issues and what's going on. So this is that for me.
Yes, the perfect way to get together and just talk about IP in the news. So that is one of the goals of this podcast, for us to get together, break down the IP news while giving you our insights into the law, hopefully provide you with some entertainment about the IP news while we're doing that, and obviously try not to steal too many ideas from our other favorite podcasts. But of course, imitation is the highest form of flattery. So let's get into it. It turns out that selecting a podcast name is really difficult. I think we can all agree that we have a new level of empathy for our clients in the process of selecting trademarks. One of the big parts of all of our jobs is counseling clients on the clearance process for trademarks, and part of that goes into providing clients with selecting and adopting their trademarks. A lot of clients will ask us for advice about what makes a good trademark, and during the clearance process, sometimes we have to send our clients back to the drawing board when they found a mark that they truly love, and that is difficult, and we had to do that ourselves when coming up with the mark for this podcast, Protected Thoughts. So maybe, Katie, you can talk us through the process of how we went through finding a number of marks, and then Pete can give us a breakdown of what makes a good and protectable mark.
Yes, so a clearance search is basically something that puts you at the beginning of the process before you even file an application with the USPTO. It makes sure that you don't get moving forward and run into issues. And so what do? You think long and hard about what you want as your trademark. You're going to take into consideration all of the things that Pete's about to tell you. You have a mark that you really like, but you still need to set yourself up for a successful outcome with the PTO and any registration there. You're going to do this clearance search. This is different than just searching the PTO's online trademark database. A clearance search provides you with basically all the records of relevant state registrations or marks that are unregistered as well. This is very important because unregistered trademarks can also give their owners rights that are senior or prior to the mark that you might have in mind. And that's just because that's the law in the U.S. Trademark rights are based on actual use in commerce and not just registration. So doing this clearance search basically helps to identify the risks of using a specific trademark ahead of time, and more specifically, whether or not there are any pre-existing identical or confusingly similar trademarks. You get ahead of the problem, and instead of putting in the work with the PTO or expending time and money to brand your business with a mark, and then ending up with the owner of a conflicting trademark asserting its prior rights against you, you can just go back to the drawing board, which is what we kind of had to do. It sucks, but it's better than the alternative, obviously. This brings us to how to choose a trademark, which I think Pete is going to discuss.
Yeah, so it's good that in our first episode, we're deciding to just give a basic rundown of really what a trademark is and what you're trying to accomplish with it, and then what is it that makes a strong mark. And I think where we start is we need to understand what is a trademark. And a trademark is, at its base, a source identifier for a type of goods and services with who it is that is selling those goods and services. And so as a source identifier, we want something for a business that is going to be protectable. And in the United States, the way that we think about protectability is really along a spectrum of distinctiveness. And where we start here is going from the least protectable to the most protectable. And where we start is terms that are generic. And terms that are generic are in the public domain. They're never protectable. And they can become generic through widespread use. So an example of a generic mark would be zipper. Zipper, something that at one point was protectable, but has now become so ubiquitous and so associated with the thing that it is representing that everybody just knows it as a zipper. If we were going to name our podcast something that was generic, we would just call it podcast. In which case nobody could protect that mark. We certainly couldn't do that. And so next along the spectrum of distinctiveness, we have marks that are descriptive. And descriptive marks are simply marks that merely describe their goods and services. An example of what a descriptive mark would be Kentucky Fried Chicken. A mark in that regard is it is descriptive of what it is, fried chicken, and the location in which it was originally sold, Kentucky. And typically those marks are not protectable unless they reach some level of distinctiveness in the community, and the public begins to associate that mark with the company and the goods and services that it sells. I would think that if we were going to name our podcast a descriptive name, I would say it would be Intellectual Property Radio. Perhaps there's a chance that we could gain distinctiveness with that, but at this time right now, we wouldn't be able to protect that mark. Next are marks that are suggestive. A mark that's suggestive alludes to the features or characteristics of the goods or services, but require something more from the consumer to make a connection, a logical leap, I guess you could say, between the goods and services and the company that's selling them. Some examples that are out there in the world that would be a suggested mark would be QuickBooks, maybe. Bed Bath & Beyond is another one. So then we move on to the marks that are the most protectable, so the strongest marks that are out there, which are what we call in the industry arbitrary and fanciful. So these are trademarks that the name doesn't have anything to do with the goods and services. And so there are examples of them that are like Apple. Apple's a great example of a very famous mark that has nothing to do with what it is that they're selling, which are computers and software. But nevertheless, it's being used by a company to represent those goods and services.
Thanks, Pete. Now, you mentioned Kentucky Fried Chicken as being descriptive, but then you also talked about how it can acquire distinctiveness over time when consumers recognize it. So, Kentucky Fried Chicken acquire distinctiveness?
Oh, absolutely. I would say that just given the sheer number of years that it's been around, it's everywhere in the United States and around the world. And certainly it's done well enough for itself. It's a company that makes tons and tons of money. And so those are the types of things that we consider to decide whether a mark that would be otherwise descriptive would become protectable.
Excellent. Thank you. So Katie talked about terms being confusingly similar when you select your mark, and Pete's talked about things acquiring distinctiveness, and these are all terms and legal advice that's helpful to consult a trademark attorney in the process of selecting and adopting a mark. Trademark attorneys often have good tips for helping you select good marks. Pete, do you have any?
Well, given the spectrum of distinctiveness that we had just discussed, I think that if you're veering anywhere that is close to what it is that you're selling, you're dipping your toe into the descriptiveness category. So the more arbitrary that your mark is, meaning the more arbitrary your trademark is, the more likely it is that it's going to be strong, it's going to be protectable, and whenever you get to the United States Patent and Trademark Office and file your trademark application, you have a better chance of getting a registration.
I agree. That kind of goes along with the tip that I like to tell clients. I always tell clients when they're selecting marks, think of it like you're building a fence. You really want to build a strong, high fence so it serves its purpose. You are keeping others out. And the more descriptive your mark is, the closer others are going to be able to get to you. So if you choose something that is distinctive, that is arbitrary or fanciful, then your mark is going to be stronger and more protectable, and your fence is going to be higher, so to speak.
And I think, Bruce and I live in the world of IP litigation, and it creates it's more of an uphill battle whenever you have a mark that's descriptive or weak in some sense. And so the stronger your mark is, the less of an uphill battle it is.
Agree. Any tips, Katie?
I like the tip to be as clever as possible with the name and be clever in relation to who you are or what you sell. So to bring it back to Louisville, which is where you guys are based, hometown hero, well, I guess he's not from there, but Lamar Jackson, who is the quarterback at U of L, he recently has filed a trademark application for the mark U8 yet with question mark, and 8 is the number 8. That is his number on the Ravens, and it's for restaurant services. So the number 8 is meaningful for him. However, it also ties back to eating in relation to the services it'll be used for. It's kind of fun, clever, something different, something that someone else probably will not choose, but also they'll relate it to him.
What about you, Bruce? Tips?
My thought is maybe the counterbalance to what Katie just mentioned, and it is, don't be so clever that no one understands it. When we were talking about potential IP or potential names for this podcast, we had some pretty good ones. but no one understood them. And when you're dealing with pronunciations, you have to assume that not everyone's going to pronounce things the way you think it should be pronounced. And so my thought is, sure, that's clever. Sure, that makes you and your friends giggle, but it may not be the brand that's going to make you the millions that you think you're entitled to.
That's a good point. So I really liked IPTTEA. What's the T in the news this week, which is kind of a play on the words, little double entendre. But when you say it out loud, nobody really, and this is a podcast, so we're talking about it, nobody would understand that double entendre. And then what else do we like?
You liked aperitif, like aperitif of an appetizer before meal, which is
A little cocktail since we're recording this after work.
And my response to that was, what's that?
I know.
So that's the thought. It's cool, it's clever to you.
But it was almost, it didn't quite hit.
You should shop it around a little bit. The other thing I would say is a lot of people, in an effort to be clever but get ahead, they will use already known brand names and try and create their own twist on that. And that's a good idea, but if you are Nike or Instagram or Facebook and you see a company out there called Face Magazine, they're gonna come after you.
So it's legally a bad idea.
Legally a bad idea. And who knows, you can apply for a trademark. You may even get it approved, but it doesn't mean that you're not going to spend a fortune trying to defend it down the road.
That's a good point. After much back and forth, we landed on protected thoughts for this podcast. So on the spectrum, where does it fall?
I would say that protected thoughts, I don't think that it's descriptive. It's definitely not generic. Like I said, I would say a generic name for a podcast is just going to be podcast. But this is something that I would say at worst, it would probably be suggestive, certainly protected thoughts that connotes intellectual property. But on the same note, I would say that it doesn't necessarily have anything to do with podcasting. So in that way, I mean, I could say there's an argument to be made that it's arbitrary. What do you all think?
I think it probably lands on the suggestive piece of the spectrum. I think you also have maybe a double entendre going on with protected thoughts and IP. What about you?
I think it's a no-brainer. I think it's suggestive.
And Katie, how did it fare in the clearance search?
So I did a very quick clearance search. It did pretty well.
So, Mary Louise, if a client came to you asking about registering the trademark Chili Crunch, what would your advice be?
Well, Bruce, that is a very timely question given the recent news that celebrity chef David Chang and his company Momofuku have been sending out cease and desist letters to users of the phrase Chili Crunch. Is anyone familiar with the story?
This was news to me.
Okay. So first, let's give some background on this. Who is David Chang? David Chang is a celebrity chef. He is a podcaster. He's an American restaurateur. He's a television personality. He has a show on Netflix. Anybody seen it? I know Bruce is familiar with David Chang. We are David Chang fans in our house. And actually, I purchased Bruce David Chang Chili Crunch sauce for Christmas one year because we are such David Chang fans. And David Chang has a podcast as well that I listen to called The Dave Chang Show. And he has some restaurants across the country, Momofuku Noodle Bar and offshoots of those, the cookbooks and things like that. So,
yeah, the first time I had heard about this was from you all, but after you all told me about it, I went home and looked in my refrigerator to make dinner that night. And as it just so happened, I was going to use an ingredient in a sauce that I was making called Chili Crisp. And then I sent you all a picture and asked, is this what we're talking about on our podcast next?
Well, yes, in fact, it is. So this chili crisp is very similar to chili crunch, I presume. It looked very similar to it. And the chili crunch comes in original flavor. It comes in black truffle, extra spicy, and hot honey. I believe that we have multiple flavors. It is described on the Momofuku website as being packed with the same umami-rich ingredients in the Momofuku restaurants. It's inspired by Chinese chili crisp and crunchy Mexican salsas. It's delicious. I think you can put it on things like salmon and eggs and noodles, and it really just gives you that extra crispy sensation and also a crunch as you eat it, and really an extra kick of spice.
Are we doing an advertisement right now? Are we getting paid for this this endorsement?
We should be. I'm a fan. But
it is good, I will say.
But to that end, it is descriptive of, in my opinion, of the condiments of the sauce. But somehow there was a registration of the mark chili, CHILE crunch, that was issued back in 2015. Now, was this issued to David Chang, you ask? No, it was issued to a company called CHILE Colonial LLC. It was issued back in October of 2015 for use in connection with different condiments and salsas. And David Chang, through the Momofuku entity, launched his product of the chili crunches, CHILE, years later. And then Chile Colonial LLC actually sued David Chang, and through that there was some sort of settlement agreement in which Momo IP acquired the common law rights and the registration to CHILE crunch, so chili crunch. And then recently, in March, Momo IP filed an application for registration of CHILI crunch for use in connection with its condiments. So that application is pending before the USPTO. Now, back in April of this year, there was a lot of buzz because it came to the public knowledge that Momo IP had been sending cease and desist letters to entities that had been using CHILI crunch or CHILE crunch in connection with these condiments or sauces. They mostly appeared to target Asian companies or restaurants, which makes sense considering these sauces and condiments that are offered under a chili crunch mark have an Asian flair to it. It, of course, made the news because David Chang, so famous, Momo IP's, well, at least in our world, is famous. And David Chang received a lot of backlash for these letters that were sent. Obviously, these letters were probably sent at the encouragement of Trademark Counsel because he owns rights and has been using this chili crunch mark for years. And so Trademark Counsel recommended that he had a legal right to do so, and to continue to own your mark, you have to police it. Regardless, he was deemed a trademark bully in the eyes of the public, and founders of the company that received the letters noted publicly that they were disheartened to see Chang's company go after brands, including, for instance, small minority women-founded business, and commenting that this, quote, sets a dangerous precedent for squashing a fair competition, not to mention how ridiculous it is to try to take ownership of a generic cultural term. And in response to this, David Chang issued an apology to the AAPI community and anyone who feels like they've been hurt or marginalized based on his actions. He noted that there's a lot of chefs that he's friends with and a lot of people that are upset that are part of the Asian American food community, and he, as a result of this backlash, decided not to enforce the chili crunch mark anymore. Now, when I last checked, the CHILI crunch application had not been withdrawn, so it remains to be seen whether he will withdraw that application, continue to attempt to prosecute the application and obtain a registration, or if he's going to let that application go. But again, if you don't police your registration, enforce rights against others that are using the trademark, you lose rights in your trademark.
Yeah, I think, I take two things away from this. And one of them is, you're right. How are you supposed to maintain your rights in a trademark unless you're actually going out there and honestly sending hate mail and filing lawsuits? Otherwise, I mean, your rights can be taken away. And then the second part is, how are you know when something like this is going to blow up in your face? I can see why, if it's somebody at least who is somewhat famous, that they run a higher risk. If the trademark is associated with them closely, they run a risk that they're going to get torched on Instagram or X or something like that. But it is a fine line to walk, is what I think this tells us.
I think this is a particularly spicy situation because the mark Chili Crunch is arguably descriptive of what the product is. And, if a client came to me, you asked that question in the beginning of this segment, if a client came and said, is this mark descriptive? I think, I don't know how I would answer. Obviously, each analysis is very fact specific. Has it acquired distinctiveness because it's affiliated with Momo IP, which is the ownership, the name of the owner of this mark, how it's registered. But I don't know what I would say looking at all of the facts, but I think just the Chili Crunch, and since it's used by so many third parties, apparently maybe it's more descriptive than a source identifier. So it's a difficult situation. But again, David Chang believes he has rights. He has that registration for CHILE Crunch, and you're allowed to prevent others from using identical and confusingly similar marks when you have a registration. So he did have a legal right to send these cease and desist letters out and take the action that he took.
And going back to what I was talking about earlier, which is the spectrum of distinctiveness, Mary Elise brought up something that's what we would consider to be evidence that your mark is actually pretty weak and not protectable, as if there are a lot of other people out there that are using similar terminology for those goods and services. I mean, that's a classic example of, if everybody else is using it, why are you special?
That's right. What do you think, Bruce?
Well, I think I don't want to say I feel bad for Momofuku or David Chang, but it's a rough spot for him because he got sued. He was using Chili Crunch, and he got sued by a trademark owner in Colorado, and it was, oddly, it wasn't an Asian company. It was listed for salsa, more of a Mexican salsa product. And in fact, if you look at the current mark for Chili Crunch that Momo IP owns, they never changed that description. It still is for salsas. And so he got sued. He made a business decision to buy that name, probably paid quite a bit of money for it, perhaps less than litigation, perhaps more than litigation, but that's always a litigation tactic. If you are going to try and settle a case, what can you walk away from the case with? And if you own the mark, that's a pretty good deal. That's a good return on investment. And then the very lawyers that probably made that acquisition for him turned around and tried to monetize it, and it backfired. I don't know if that's a cultural difference that he wasn't anticipating. Certainly a cultural difference that his lawyers may not have recognized. But I feel bad for him in a way, because that was the investment. And I don't know. On the other hand, David Chang is not going to lose street cred because of this. His business is not going to diminish. Everyone knows the Momofuku name. We're still going to order expensive cakes from Milk Bar.
Yes, we are.
And we're probably going to put more David Chang inspired books on our bookshelf. So I think he's doing okay. I think if the question were Momofuku, which, by the way, I assume is pretty distinctive. That brand name is still good. The Chili Crunch is probably expendable, and especially given the cultural hit in the community that he very much calls his own, that was the right business decision.
And he can still sell it, right? I mean, there's nothing that just because he doesn't have a trademark or a registration doesn't mean that he has to stop using it or that he can't keep selling that product, right? I mean, it's just he has voluntarily withdrawn his enforcement rights.
Right, and that's a really good point. So it's not always the business decision that clients make is not always the legal decision, right?
Mm-hmm.
You sometimes have to make a business decision that doesn't align with the absolute legal right that you have, and that's the best decision for the client.
But we all do agree that there probably won't be any more lawsuits or cease and desist letters going out, right?
Not from David Chang on that front.
No, I don't think so.
This David Chang cease and desist kerfuffle reminds me of a situation involving Luke Combs. Katie, can you remind us what was in the news about that?
Yeah, so Luke Combs basically sued a lady in October of 2023, so pretty recently, along with a lot of other online retailers for selling counterfeit versions of his trademarks. And this leads to Nicole Harness in Florida finding out that she had a $250,000 judgment against her for selling only $380 worth of unauthorized Luke Combs homemade drink tumblers with Combs's name and likeness on them. So even worse, she was unfortunately hospitalized for a chronic heart condition when the suit was actually being decided. So she never even knew that she was being sued. The summons was actually served to an old AOL email address, and it went to her spam folder. So she obviously never checked that. So imagine being served with a lawsuit to like Pink Soccer Girl 1990, which I can neither confirm nor deny as my old AOL address, which is, yeah, so pretty brutal for poor Nicole Harness in Florida. So as far as the claims in this suit, there were two causes of action in the complaint. First, they alleged trademark infringement and counterfeiting based on defendants' unauthorized use in commerce of counterfeit imitations of registered Luke Combs trademarks in connection with the sale of infringing goods. And then second is a false designation of origin claim, and that claims that defendant's sale of the counterfeit Combs products created a likelihood of confusion for the consuming public as to the association with Combs and the counterfeit products. So in this complaint, Combs asked for specific damages, just to drill down into the ones that matter to Miss Nicole Harness. Combs asked for treble damages for use of a counterfeit mark under Section 1117B of the Lanham Act, and then in the alternative asked for statutory damages for use of counterfeit marks under subsection C of the same section. So in Combs's So no one responded. None of the defendants responded, which means that Combs filed a motion for default judgment. And he asked for statutory damages in the amount of $250,000 for each defendant. This is interesting. To cite or to support this amount, he cited to a previous Luke Combs case from 2021, in which the Northern District of Illinois actually awarded a judgment of $250,000 per defendant to each defendant under largely the same circumstances. So that being said, the court ordered a default judgment, and the court awarded statutory damages of $250,000 on each of the defendants, including our sad Florida lady, for the willful use of counterfeit Combs trademarks on products sold online. Basically, this makes Combs look like a monster when you put it in the context of our humble Florida defendant. But credit to his PR team because and this is opposite of the David Chang ordeal, he got out ahead of it. As soon as her story hit the media, Combs called her to apologize, and then he put a post up on his Instagram responding to the story. I actually watched the video, and this is exactly what he says. "What's up, guys? Luke here. It's 7:27 a.m. here in Tennessee. I woke up at 5 a.m. to use the restroom, and first thing I saw was this." So, I mean, there's a lot of details there, including about going to use the restroom, but it's important he did that.
Also tells you what he does when he's using the restroom.
Exactly. I don't think he recorded the video on the toilet, though.
Thank goodness.
But you never know. Maybe he does some songwriting there. I don't know. But anyways, he told the media that he doubled the $5,500 that his lawyers had actually seized from Miss Harness's Amazon account, and then that he would actually sell his own tumbler in his store to raise money for her medical bills, and then he invited her to meet him at a show. So Combs was the hero once again. Basically, he's kind of done the opposite of what Chang initially did, and now Chang is cleaning up his mess.
Well, the Combs, to give a little more context on this, it is a pretty standard operation right now for intellectual property owners to file blanket lawsuits in the Northern District of Illinois, and they identify store names. So, to your point, Katie, it could be the storefront name could be Pink Soccer Girl or what have you. It wasn't in Nicole's name. And so what the plaintiffs do is they ask the court for temporary injunctions against the stores and the sellers, and they ask for an order against the online stores to unmask those sellers. So that's how Combs found out who this person was, sent the email. Legal issue aside, email service isn't usually good service, so this is just a world unto its own. And Combs arguably didn't know who this was. He filed suit in the Northern District of Illinois. The complaint largely alleges Asian overseas counterfeiting operations, and he just stumbled into a person sitting in Tampa, Florida. So
Exactly.
the only other thing that I thought was a little icky, but it keeps his rights going, is he could have vacated that $250,000 judgment against her. He could have withdrawn it, told his lawyers, I don't want to go after her. I would rather just go after the others and not make her pay the judgment at all. That is not what he did. He kept the judgment against her. He got good PR for raising money for her, raising money for her hospital bills, and that enabled him to keep the judgment against her while being the good guy and protecting his mark.
So is this the move? Is this how IP owners can appropriately enforce their rights and then simultaneously look good in the eyes of the public?
Maybe less sloppily, but yeah, that's if you compare it to the David Chang situation, David Chang basically took his mark off the table, said, I'm never going to enforce this again. And so who knows if it's a valuable right that's worth enforcing. But it's gone. He's got a registration to something that he's now effectively abandoned in any claim against anyone else. Meanwhile, Luke Combs didn't say, I'm not going to do this anymore. He said, I'm sorry to this person, and he kept his judgment in place, and all of the other judgments that he's obtained in the Northern District of Illinois.
It would be interesting to look and see who and how many additional lawsuits Luke Combs has filed, since, as you said, it's a common practice for these sorts of filings in the Northern District of Illinois. So I would be interested to know what has happened since this order.
Something for us to research for the next pod.
Bruce, let our listeners know where they want to tune in if they would like more information on sending or responding to IP cease and desist letters.
Yes, Mary Elise. On Friday, May 10th at 2:15 Eastern Time, Mary Elise and I will be presenting on this topic at the KBA Annual Convention. That's at the Marriott in Covington, Kentucky. I will be discussing some of the basics of copyright infringement, enforcement. Mary Elise will be talking about trademark registration and enforcement. And then we'll be talking about what trademark and copyright owners need to do to protect their registrations, sending cease and desist letters and not making the news, preferably. And then also, more frequently in our world, is how to respond to these cease and desist letters. Just a few pointers. Knowing the basics about copyright and trademark infringement will help lawyers in assessing those cease and desist letters, and to avoid the trademark trolls and the trademark bullies of the world.
Do you have any words of wisdom for our listeners today in advance of this presentation?
Don't ignore cease and desist letters. And if you stole content, stop.
Yes, good advice.
Yeah, you infringers out there, stop that.
I think that is enough content for one episode. What do you guys think?
Yeah, I think we're wearing down.
Episode 1 in the can.
Thank you all for listening to our inaugural pod. This is Protected Thoughts, and we will see you next time.
And remember, we're lawyers, but we're not your lawyers, but we love talking about the law.
We'll see you back here next time on Protected Thoughts. Check us out on McBrayerFirm.com.
Thank you very much.
See you next time.
See ya.
Bye, everyone. See you next time.
All content copyright 2024 McBrayer PLLC. All rights reserved.